These consultations took place in Washington. They did not achieve a positive result. Venezuela therefore had no recourse but to ask the WTO to establish a panel.
Brazil also complained to the WTO about the discriminatory aspects of the US regulation. The two complaints were heard by a panel appointed in April 1995. The panel consists of 3 independent experts chosen by both sides in a dispute. The United States denied that it was discriminating against imported gasoline. It claimed that clean air is an exhaustible natural resource and that it was therefore justified under Article 20 to take measures to preserve it. It also claimed that its regulation was necessary to protect human health, which is permitted under another Article 20 exception. However, in January 1996, the panel ruled that imported gasoline was indeed discriminated against and that this could not be justified, even under Article 20. A month later, the United States appealed the panel's conclusions. Its appeal was based on the argument that clean air is an exhaustible natural resource.
The government was very concerned about the interpretation that the panel had made of the General Exceptions Clause, Article 20.
Appeals in the WTO were heard by the appellate body. This is a permanent group of 7 persons of recognized authority with demonstrated expertise in law and international trade. It does not look at new evidence, but only at points of law and interpretation of WTO rules by the panel. Within 2 months, the appellate body issued its ruling. It confirmed the panel's decision that the discrimination against imported gasoline was not justified under Article 20, but adopted a broader interpretation of this provision.
The United States was not satisfied with the outcome of the appellate body proceeding in that it was still uncomfortable with the interpretation of Article 20, particularly with respect to future conservation and environmental measures. But I think it's fair to say that the appellate body interpretation of Article 20 was better than what the panel had left. And so in that sense it was an improvement.
No further recourse was available. The appellate body report and the modified panel report were adopted by the dispute settlement body in May 1996. Just over 1 year after the panel was appointed. The complaining countries were satisfied with the outcome and the way the dispute was handled.
The resolution of this case confirmed that the new dispute settlement system was working in a neutral way, a way in which developing countries could trust.
The European Union had a substantial interest in this case and participated as a third party.
The case became all the more interesting on appeal when it turned out that the appellate body had a slightly different view of the matters on the details of the exception of the gas to and slightly modified the findings of the panel. But we were very happy with the way the appellate body did that, and the firm way in which it grounded its decision in the principles of international law and treaty interpretation.
The case was not over. The United States had to implement the ruling. It had to change its regulation. It discussed with Venezuela and Brazil how long this should take.
So it required regulatory action. In the United States, that meant notice to the public of a proposed new rule, seeking comments, a public hearing if requested, and then the publication of the final rule. And all that was going to take time. The political context was rather harsh, and yet we were able to negotiate with the various interests involved, conservation and environmental groups, The EPA itself and the government authorities that are chiefly involved in the regulation of the environment, and our foreign trading partners.
In the end, the two sides agreed on the timing. The United States implemented the necessary changes to its legislation within 15 months, and the dispute was over.
Yeah, I just want to pause there for a minute because I want to highlight a few things. So, theme of this class, rule of law versus rule of force, right? So one of the ideas behind setting up this kind of system, and that's what they kind of talked about, is that now smaller countries, Venezuela, et cetera, have the ability to take a complaint against the U.S., much larger economically, et cetera, and have a system that they can trust, as opposed to having to directly negotiate with the U.S., which they tried and it didn't work. And that's why it's so important to understand the significance of this. It's the first major case that went through the WTO system. So it was a test on the credibility of how that system is going to function. Now, obviously the U.S., when he said the political environment was harsh, what he meant by that, there was a lot of criticism domestically here in the U.S. about this whole case for a couple reasons. Number one, you now have an intergovernmental organization, the WTO, essentially telling the United States what their law has to be. Because we have these environmental standards that were written by the EPA, it's an administrative rule. And you now have the WTO saying you have to make your rule different. So you've got an intergovernmental organization telling a sovereign country that they have to change their law. I mean, that's, in a nutshell, what's going on. That's why there was a lot of controversy about that, because the idea is the United States is basically giving up its right to control its environment. There was a lot of protesting and everything else about it. And so the idea with this whole dispute settlement system, which is also important in the background, is the United States followed it. We talked about this at the beginning. Why would a sovereign state agree to limit its power in international law? Because that's essentially what happened here, right? Why? Well, the United States understands, even though it's politically difficult, that they have to follow these rules and decisions by the WTO, or the whole thing just kind of crumbles. Because if the U.S. isn't going to follow it, nobody else will either, right? And so it's rule of law as a theory, as this idea that you've got to follow it, because if you don't, nobody else will. This is highlighting that specifically. Also from a legal standpoint, becoming a member of the WTO, you have this obligation to follow these decisions. And through our Constitution, the Supremacy Clause makes treaty law part of U.S. law. And so what had to happen then is, this is what the lawyer there at the end was talking about. The EPA had to go in and rewrite the administrative rule to essentially reduce down those standards. So you had two sides going on in the U.S. at that time. One side was the oil industry, of course, saying, well, we don't want you to apply these rules that you previously were applying to Venezuela domestically because it was so expensive. They would have to retool everything in the refineries. And then on the other side, you have environmental groups and intergovernmental groups saying, you need to apply those rules that were being applied to Venezuela and Brazil, et cetera, domestically in the U.S. because they set a higher cleanliness standard. So internally in the U.S., you had this political tension going on at the same time. So that's why this is such an interesting thing, both from a theoretical standpoint and a reality standpoint. You've got to follow through, even though the U.S. doesn't like this outcome, you've got to follow it, or the whole system just loses all credibility. Since that time, there have been dozens and dozens and dozens of cases that have worked their way through the WTO system. But had this essentially turned out so that the U.S. decided we're not going to follow that decision, essentially this whole dispute system would have just gone away. And that would have potentially led to a trade war in a way with petroleum. This keeps going for a while and it gets kind of off topic. So I'm gonna turn it off right now. And I think we're gonna go ahead and break today at that point because I don't want to start the next